We are all of the view to dismiss the appeal for the unanimous reasons of the Court of Appeal for British Columbia.
And with that, BC's challenge against Trans Mountain is over late this afternoon in a unanimous decision. Chief Justice, as you saw there, Richard Wagner, said Canada's top court will let the BC Court of Appeal decision stand. That decision quashed provincial legislation designed to block the TMX pipeline expansion. The CBC's John Paul Tasker is here with the developments. Hey, JP. Okay, so what exactly happened in court?
Yeah, so what we have here is a stunning blow to BC's attempt to try and stop the Trans Mountain expansion project. John Horgan was elected in 2017, saying that he was going to use every single tool in the provincial toolbox to stop the project. Well, now he's out of tools because the Supreme Court has ruled that the legislation they want to bring about to force the federal government to force the owner of the Trans Mountain project to get permits to move bitumen through that province, they found that to be unconstitutional because it infringed on the federal right to approve these projects, the interprovincial pipelines that travel between provinces. They said that BC cannot impose its own set of rules on a project that that Ottawa's already signed off on. So a major blow to John Horgan in his attempt to try and stop this. He's already been stopped previously in other court decisions, but this is the last straw for him in terms of what he was doing. And it really came down to the Supreme Court justices arguing that they had no right to do this. This is well built beyond the provincial jurisdiction. Malcolm Rose saying that it would set a dangerous precedent for the Supreme Court to allow this sort of condition on a federal project. Take a look.
Heavy oil today, anything else tomorrow. It seems to me that this legislation is about taking away the ability of the Government of Canada to effectively approve interprovincial pipelines.
So he's referring to Section 9210 of the Constitution, which makes it very, very clear that any interprovincial project falls to Ottawa. Rosalie Abella, another Supreme Court justice, picked up on that point today, saying it's fine for the government to introduce environmental legislation to try and protect its landscape, but this was just not the right way to go about it. Here's Rosalie Abella.
So I think that's really what we have to deal with. Not is it important to protect the environment? Of course. Can it be done this way in a way that interferes with what is unquestionably a federal undertaking?
I should say things did not go well for Joseph Arave today, the lawyer who was representing the BC governor or the attorney general in court. He basically conceded at the end of his hearing that he was probably going to lose, but if he's going to lose, he didn't want to lose badly. Well, that didn't go according to plan because this is really a rare bench decision. We don't usually see the Supreme Court hear oral arguments one day and then come back half an hour later and make such a strong decision, unanimously striking down the BC legislation that would have imposed those permits on the project.
Definitely rare. This isn't, however, the only hurdle, and there have been many in the history of this pipeline expansion. This isn't the only one that it has to face. There are still some other ones.
Yeah, we've been talking about this for years, you and I, on this program, about all the hoops they've had to jump through to get this project built. Let's go back to 2016 when Prime Minister Justin Trudeau and the Liberal cabinet first approved this project. They put some conditions on it. They recognized that it would have an effect on the environment of British Columbia, but that wasn't good enough for the Federal Court of Appeal. They quashed cabinet approvals of that project in summer 2018, so the government had to go back to the drawing board and redo some of the consultations with Indigenous peoples, redo some of the environmental assessment review, especially as it related to marine life. They did all that. They sent 60 Crown consultants to 117 communities under the guidance of Frank Iacobucci, but that still wasn't enough for the Federal Court of Appeal, who has now decided, or had decided last fall, I should say, to hear another set of appeals to this decision. So while it's cleared the Supreme Court of Canada and this BC reference case, the project still has to go through the Federal Court of Appeals process with the Indigenous consultation aspect still in question. And
we're seeing reaction. I saw Premier Kenney as well as Natural Resource Minister Seamus O'Regan tweeting out their support of this decision, unsurprisingly.
Yeah, so just into our newsroom now, Minister Seamus O'Regan, who is of course the Minister of Natural Resources, just released a statement. He said he welcomes the Supreme Court of Canada's decision. It's a core responsibility of the federal government to help get Canada's resources to market and support good middle-class jobs. We know this is only possible when we earn public trust and work to address environmental, Indigenous peoples, and local concerns, which we are doing every step of the way with TMX. So we expect to hear the ruling of the Federal Court of Appeal on those appeals that I mentioned earlier, probably within the next number of weeks, because they did wrap up all those hearings just before Christmas.
All right, thanks, JP. Appreciate the update. The CBC's John Paul Tasker.
We're now ready to release our decision. And first of all, I'd like to thank all council for their great submissions today, all day. We are all of the view to dismiss the appeal for the unanimous reasons of the Court of Appeal for British Columbia. Thank you.
And with that, BC's attempt to control which resource projects run through the province is over. The Supreme Court, as you heard there, unanimously decided to toss British Columbia's appeal less than 2 hours ago. The case stems from legislation designed to block the Trans Mountain Pipeline expansion project. Last spring, the 5 judges of the BC Court of Appeal ruled unanimously against the government on constitutional grounds. So does this mean TMX is one step closer to completion? And will the ruling affect other provinces wanting to veto interprovincial projects that cross into their territory? Let's bring in the power panel. Jason Markisoff of Maclean's joins us from Calgary. Over in Toronto, David Hurley, partner in the Gandalf Group and host of the Hurley Burley, joins us, as well as next to him, Andrew Thompson, Chief of Government Relations for the University of Toronto and a former Saskatchewan Finance Minister. Here with me in studio, Rachel Curran, former Policy Director to Stephen Harper. Hi, everybody. Hi,
hello.
Nice to see you. Jason, I've got to start with you. How impactful do you think this decision is?
I mean, it's one of this. It's, you know, of the many surprises on this long-standing file. This is probably the most. This is not a surprise at all. This was seen as a dead-on-arrival piece of legislation, an irritating one, a very frustrating one. Ultimately, the piece of legislation that probably forced Kinder Morgan to bail on the project and for Ottawa to purchase the Trans Mountain Pipeline. But this was always a legally dubious plan by the BC government and John Horgan, just one of the more public tools in their toolbox, as Horgan was fond of saying. You know, Jason Kenney is hailing this as a victory. This is one more step. There is another, you know, the more tricky and more worrisome legal shoe to drop is another ruling from the Federal Court of Appeal. From a few First Nations bands. That's the same sort of a challenge that had the project kiboshed for several years in 2017 or 18. So you know, I think a lot of people out here, and I think even in BC, Horgan has seemed to say that he's done fighting this project, or he's largely lost passion for fighting this project. Hopefully this will, you know, hopefully from a lot of people out here, this will be, you know, smooth the process and also build confidence that this project will in fact go ahead. It is already under construction in much of Alberta.
Jason brings up a really interesting point, Rachel, in that so much of the tension where BC was concerned years ago ended up actually killing private sector interest in it, right? Yeah. And the appetite for it. But now, as it makes its way through the courts and we see the manifestation of all this, even John Horgan's rhetoric changed drastically over the last year. He sort of said, yes, I'm going to use every tool in my toolbox, but if the tools don't work, you know, kind of threw up his hands a little bit.
Well, yeah, but look, the tools have worked. Look, I am very pleased with this decision. Like, it's the first piece of good news we've gotten from the courts on pipeline projects in a long time. I'm hopeful that the federal court will be listening to and taking into account the pretty serious public policy issues here, including the ability to keep our economy running, including the ability to keep our country unified. Those are all pretty important things that the courts need to consider. But look, the federal government had to buy this pipeline because the private sector proponent backed out. And one of the judges said on the Supreme Court today, said, look, if we sided with BC, the uncertainty would kill the business case for the project. Well, the uncertainty already has killed the business case. The private sector proponent's long gone. So the government now owns this project. And by the way, no one else from the private sector wants to invest in resource development projects in Canada either. So we are already at crisis stage in terms of private investment in this country. And so, yes, this is a positive signal, but let's not, you know, pretend that this is going to fix a very serious problem that already exists.
David, fair point?
It's absolutely a fair point. I mean, I think the problems with private sector investment in the Canadian oil sector are broader than just uncertainty about pipelines. I think it's a global trend. But nonetheless, I think that Rachel's right. But, you know, your point is also right, which is that Horgan always knew this pipeline was going to go ahead and this legislation wasn't going to work. And it's something we're seeing now, which is that governments are using courts in a political way to advance a political argument. So this was Horgan's way of saying, I wanted to stop the pipeline, I couldn't, the Supreme Court blocked me. It's very similar in theory to the governments that took the federal government to court over the carbon tax. And in fact, many people argued that the Trudeau government should have made the courts force them to pay Omar Khadr rather than make that decision themselves. So there's an increasing trend about using courts as political tools in Canada.
That's a really good point that I hadn't actually thought of it that way. Andrew, what about you? I mean, especially, I had just noticed that John Horgan, his rhetoric had changed, right? He wasn't up there saying, I'm going to stop this at all costs. He was deferring to the courts very readily and often over the last year.
Well, he's a politician, and I think he's taking a look at what the polls are saying, and he understands where his battles need to be fought. I don't buy into this argument that somehow there's more interventionist activity by the courts or the politicians are using the courts any differently than they ever have. The issue over resource management has been an issue in this country since the 1930s, if not before, and will continue to be as we move forward. The issue here, I think, would be completely different if we were talking about Quebec, and people would be appalled that Quebec wouldn't be able to stop this type of a project as it has basically through a bully tactic on Energy East. So, you know, the courts need to do what they are designed to do, which is to put in place a set of rules that everyone has to follow. Everyone understands what the parameters are for engaging them, and I don't think that this has either created a crisis of confidence in terms of investors in the oil patch. That's been existing for some time, and they've really failed to step up in a lot of ways to protect their industry and to make those investments in Canada. And in terms of the way the federal and provincial governments work, you know what? They're doing what they've always done.
Jason, on that issue of crisis of confidence, what do you see on the ground in Calgary?
I mean, people are, you know, there are still people who are very skeptical that this project will go ahead. They look at the heavily, the already approved in the works Coastal Gas Pipeline, and they see the tensions up there. They see how the murky territory where UNDRIP is going and how that will be treated by the courts. They know that this is still, you know, and they also are aware that some of those tactics used up in Northwest BC may also be used by some First Nations activists and environmental activists when the Trans Mountain Pipeline gets actually to the construction phase through BC, through Burnaby. But just to David's point about we talk about vexatious litigants, and they get penalized in the court system. There is this new class, or maybe rising or prominent class, of rather shameless, vexatious legislators. In response to this, let's remember this legislation from Horgan, which was clearly unconstitutional from the start. We had a response piece of legislation from Rachel Notley and her government to turn off the taps, and it was such a vexatious piece of legislation that she warned Jason Kenney, her successor, not to enact it into legislation because it would be struck down. That's how shameless she was, and it's actually a shame that there's no political penalty, it seems, for producing such shameless legislation. You
know what? I've got to take exception to that, because what is broken down here is any sense that the federal government has a responsibility to actually work with provinces. And this is a failure of executive federalism in this country. It is not a fact of a set of politicians deciding to overstep their bounds or become all uppity. What we've had is a situation where the federal government. Well, that's not how you're portraying it. No, the court has said that there is no ability to use that provision in that regard. That's what a court's supposed to do. But the failure here is that we've not put in place any kind of a process that allows these major projects to move forward, to build that kind of national consensus. The consultation on TMX was a disaster by both the Conservatives and the Liberal governments, and that is what has backed this whole project up. So there's a number of other failings in here that have nothing to do with whether it's vexatious litigation on the part of a province. This is a very fundamental part of the way the Federation works, and it's simply at this point not working. So everyone's moved back to use the tools that they believe are available to them.
I want to get a quick response from both David and Rachel. Yeah, go ahead, David.
Legislation that fared this badly in the courts was almost certainly the people in the Justice Department of British Columbia almost certainly advised the government that this legislation would not survive a court challenge.
Probably true.
The lawyers for the Attorney General today at the end of the hearing said, I know we're going to lose this, I just don't want to lose it badly. To your point, David.
Yeah, well, look, so I'm sympathetic to that. This is not vexatious legislation. It's a real frustration on the parts of government. on the part of government who just can't get anything done and can't get anything built. So look, I absolutely agree with David on this. The courts are being used as a political tool by various activist groups, and the idea isn't to succeed or to get, a positive outcome legally. The idea is to delay a project long enough that it will never be built.
Well, just like the Conservatives did on the carbon tax.
We'll exit the market. I mean, that is the strategy.
Andrew's point is that Andrew is saying that's what the Conservatives are doing when it comes to the carbon tax.
Well, I'm going to dispute that. Of course, there are some real legal issues at play there that need to be.
The good thing is we've talked about carbon tax about 1,000 times. I'm sure we'll talk about it 1,000 times more. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.